Summer Makita versus Mark Makita. Attorney Matthew Hauser for the plaintiff. The defendant is not here.
Good morning to both of you.
Good morning, Your Honor.
This matter is set before the court today on obviously on a show cause from the referee, as the defendant in this matter has failed to produce the child for purposes of the interview as it relates to the pending custody proceedings with the referee. It was originally set for July 10 to August 5th, 2024, and then re-noticed for today's date. The court will note for the record that staff has been in phone contact with the defendant and informed him that he had to have the child. He or someone else had to have the child in court today to be interviewed by the referee. We have in fact been in touch with the referee to set that up so that he could interview the minor child in this matter. Mr. McKediak stated he was not going to be present because apparently he recognizes he has an outstanding warrant, and as a result, he wasn't going to be here. We just stated the purpose is to have the child interviewed, so we did not care at that point who brought the child, as long as the child was produced. And it is now what is it now, 8:51 a.m. The matter was set for 8:30. He has still not appeared and has not produced the child for the interview. So, Mr. Hauser, what is your preference on how we proceed?
Well, I mean, Your Honor, the first concern, as has been expressed to the court, is the safety and well-being of the two children. As relates to the party's minor daughter, Miss McKediak has not seen her in over a month and a half. She was able to see the minor son, Mark Jr., 2 weeks ago when there was a camping trip that was allowed by a dad. Since then, there has been some phone contact. As relates to the minor daughter, Aubrey, Miss McKediak has been informed by the school that she has missed 2 days so far of their new school year. As of today, they've only been in school for 7 days. I guess the request at this time is that a order would end, or I guess I'm phrase that. It was my understanding that the referee could not produce a recommendation off of the evidentiary hearing that we had back in June until the interviews were conducted. The interviews have not occurred as the defendant has failed to produce the children for those interviews twice. When we were actually back before this court on a separate show cause hearing a few weeks back, this court informed Mr. McKediak at that time of those interviews. He continues to dodge and fail to appear. There is continued concern. So we would ask for at least a temporary change in the current order that's being contested from Grand Traverse County to allow the children to return to the care and custody of the plaintiff until we can get the children in for the interview. Ms. McKediak is certainly ready to produce the children for the interview. And at this time is the only party who has consistently appeared before the court and has complied with all of the orders of the court. Besides that, due to Mr. McKediak's failure to appear, we would ask for a bench warrant to enter against him. And if the court would be so inclined to have him picked up, brought to court to explain why he has yet again failed to appear for these proceedings.
Okay, thank you.
Thank you.
Well, as much as I would like to grant your first request for relief, Mr. Hauser, as the appellate courts have repeatedly stated that the court cannot change custody without an evidentiary hearing, which is what we're going through with the referee. And but the court will, in this matter, based upon the history, based upon what's happened, and the admonition to the defendant repeatedly in court proceedings and through staff that he had to produce the children, the court will enter a bench warrant for his arrest as a result of his failure to produce the children for purposes of the interviews. In view of, his repeated lack of compliance with orders and the admonitions to produce the children, the court is going to set that bond in the amount of 0, as the court will not set a bond amount, which would allow him to bond himself out until such time as there is a court hearing in this particular matter. So the court will again, enter a bench warrant. I asked Mr. Hauser that you prepare the bench warrant, set it as a zero bond amount. And then once we get that, we will again handle that and process that through the sheriff's department and attempt to get them out to again to pick up Mr. McKediak to bring him into court on this one and on the other bench warrant that he has. And then at this point, we'll just proceed. We do have on September 12, 2024, 8:30, our other show cause hearings as it relates to his failing to comply with the orders. So anything else, Mr. Hauser?
I guess just, yes, we'll certainly get that bench warrant prepared and sent over to the court. Right now, as the order currently stands, the parties do have joint legal custody. In the event Mr. McKediak is picked up on a bench warrant, as right now, Ms. McKediak only has the supervised parenting time. Is there any ability to include provisions that if he is picked up, the children should be returned to her pending any future court?
I cannot do that prospectively.
Okay, because we end up with a situation of I don't know where the kids are going to be if he is picked up, you know.
And I don't know either, and they just can't do it prospectively if that changes. And if the children were to be in a position where they were without proper care or supervision, then the court could enter an order at that time.
Okay. Thank
Okay.
you. And I get in the second point, as it relates to our show cause on the 12th, as it is currently set via Zoom, we would request that be amended to be an in-person show cause.
Well, let me tell you, I am going to be out of state at that
Oh.
date, so I'm not going to be able to handle it in person. But hopefully we'll be able to get Mr. McKediak picked up and we'll be able to process it that way. And obviously, if he's picked up, court will probably have him retained until such time after the hearing, so he will be in custody.
Okay, all right.
Okay,
Thank you very much, John.
the sooner you get that in, the sooner we can get it processed and go. So,
Oh, yes.
Okay, thank you.
I'll work on that now. Thank you.
okay, thank you. You're free to go. Have a good day.
You as well.
And recess. The court notes that it is now 1:11. The matter was set for 1:00 p.m. First thing I'll do is I'll let the deputy release the deputy so you don't have to stay, and you have a good day.
All right.
Again, we had this matter was set for today's date to be an in-person hearing. The parties were noticed out to this fact last week when we had the motion on the 19th, and they were told that it would be in person. And then subsequent notice was sent out, noticing it as an in-person hearing, and the the plaintiff is not shown. Ms. Henderson, what are your thoughts?
Thank you, Your Honor. We would ask for a bench warrant to be issued due to failure to appear. Further, I would ask for the show cause hearing to still proceed. My client is prepared to testify as our witnesses. We would ask for the relief sought in the show cause motion. I would also argue that the motion that plaintiff had filed back in the beginning of July, but noticed up for today for modification of parenting time should also be heard, as that was part of today's hearing.
Okay. Mr. Bland, your response.
Well, thank you, Your Honor. I anticipated, even as of last night, that my client would be here today. I received a phone call actually as I was parking my vehicle out front of the courthouse at 12:31. Ms. Coolidge indicated to me that she was having car trouble. She was still in Indiana, that she had driven her car to a dealership and she would not be able to be here. So I told her I would indicate that to the court. Obviously, given that, I would ask that, due to the fact that that's extenuating circumstances, that she either A, be allowed to appear by Zoom, or B, that she be allowed to appear by telephone, or that the matter be adjourned. I appreciate what counsel said. I'm not trying to dispute her. I'm just trying to deal with the circumstances I've been presented.
Okay.
Likewise, on the motion, my motion, I would ask that it be adjourned, and or at least I'd be allowed to withdraw it and renotice at a different time. I was anticipating testimony to support that, and I don't feel I can do that without my client. I don't think it carries. I don't think it's on the same level as maybe the show cause and so forth, but I guess the court's aware of how I would like to proceed.
Okay. Ms. Henderson, any response on this desired motion to withdraw or to withdraw the motion?
Well, I think, Your Honor, withdrawal of the motion will just get it refiled and we'll be here again. My client will be accruing more attorney's fees. At this time, the motion was filed 2 months ago, approximately. I think it's appropriate for the court to hear it. Testimony is not necessary for the motion hearing, only for the evidentiary hearing, which would be ordered if the court finds that there's proper cause and change in circumstances. So at this point, I would ask for the court to proceed and decide that motion, and then further to issue an order that would prohibit Ms. Coolidge from filing any similar motions for a period of 6 months at least.
Okay,
Thank you.
Well, in this matter, court does note that Mr. Bland's obviously in a difficult position with not having a party present to, again, present proofs in this particular matter. Regardless of what we think as to her motives in not appearing today, is the fact that he's not able to proceed with his motion. As it's his motion or the plaintiff's motion, he has a right to withdraw his motion if he wishes to do so. And as a result, the court will grant the motion to withdraw his motion for modification of parenting time at this point. Court will, in this matter, enter a bench warrant for plaintiff Samantha Coolidge for a failure to appear at this hearing, notice to appear in person. She had repeated communication to appear in person and has not appeared. And as a result, the court does believe it's appropriate. Court will enter a bench warrant for her arrest, and the court will set a zero bond in this matter so that she's not able to be bonded out till such time as she comes before the court. And I guess I'll ask Ms. Henderson that she would prepare that bench warrant and the zero bond. With that, we're ready to proceed on the defendant's motion in this matter. Ms. Henderson, do you wish to make an opening statement or proceed to proofs?
Your Honor, we would proceed to the substantive portion of our hearing. I would ask for our witnesses to be allowed to be sequestered.
Okay, we can sequester the witnesses if you wish to do so. So,
Just to be fair.
yep, you'll have to wait outside until we call you.
Your Honor, as a logistical matter as well, since we filed the motion, another parenting time denial occurred. So in our motion, we referenced August 1 through 4. Our motion was filed on August 5th. Since that time and previous to the motion hearing on the 19th, my client was also denied parenting time on August 15 through 18. And with that, I would ask for my client to be allowed to testify, please.
Okay, well, let me give Mr. Bland an opportunity to make an opening statement if he wishes to do so, or waive the opening statement or reserve the opening statement.
I would waive, Your Honor. Thank you for the opportunity.
Okay, thank you. Sir, what we'll do is have you step forward. We'll have you sworn in, and then we'll
Thank
proceed.
you. And are you the father of Mackenzie?
Yes, I am.
We filed a motion asking for plaintiff to show why she's not complying with a parenting time order. You alleged in that motion that you were denied parenting time on August 1st through 4th. Is that correct?
That is correct.
Was there any communication previous to that parenting time between you and Ms. Coolidge where she advised you she would not be bringing the child?
Casual text messages, saying that she was not going to show up.
And that communication occurred right after the hearing on our third motion for contempt of court that we had heard by referee Larry Snyder the day before on July 31st. Is that correct?
That is correct.
And do you recall if referee advised Ms. Coolidge to follow the court order at that last hearing?
Yes,
And did she in fact follow the court order and produce the child?
she did not. She has not been.
Okay. I understand that your mom did transport for that particular parenting time. Is that correct?
That is correct.
And we'll ask her about the details of that. Following the fact that Ms. Coolidge did not show up to the parenting time exchange, did you hear from her?
I did not know.
Did you reach the child through her own phone?
I believe I'm still blocked.
So you tried to reach, but you were not able to get in contact? And how do you know that you're still blocked despite the court order?
When I send the text, it says it's got the green bubble, not the blue. That means it's delivered on the iPhone.
Okay, and Mackenzie has an iPhone?
Correct.
Okay, and so do you?
Yes.
Okay. And following that denial on August 1st through 4th, did you plan and did you in fact effectuate the pickup of Mackenzie on August 15th?
Yes, we did.
And did you transport or did somebody else transport?
My girlfriend Sierra did the travel down there.
Again, previous to August 15th, did you receive any communication from Miss Coolidge indicating she would not be bringing the child?
This time I don't believe I did. I think all she wanted to talk about was the therapist stuff.
And at that time, on August 12th, referee Snyder issued an order that ordered both you and Miss Coolidge to communicate via app close, correct?
Correct, yes.
And did you in fact set that up and send Miss Coolidge an invite?
I did, yeah.
And so that was the week of your parenting time. Did she accept that invite?
It took her, I think she just accepted it a few days ago.
So it took her some time
Yeah,
to
took
accept
her
it.
over a week after, yeah.
Following the August 12th order that you are to communicate via app close, did Miss Coolidge in fact communicate with you previous to the August 15th parenting time on app close?
No,
How did she communicate with you?
the same via text.
And another thing we alleged in our motion was the fact that Miss Coolidge was already ordered to pay attorney's fees in the amount of $447.50. And that was a result of the first order following our contempt motion, as well as $100 fine to your counsel as a result of the second motion. Those were to be paid by July 20th and 29th respectively. Are you aware if she has done that?
I have not received anything.
And the third order regarding contempt also ordered attorney's fees to be paid by Ms. Coolidge. Is that your understanding?
That's correct, yeah.
And in relation to your motion for show cause, what are you requesting from the court today?
It was like, we've been asking for the last 8 months or so. I just want that court order to be followed. I want to see my daughter. That's all it boils down to.
Are you asking for makeup parenting time of 8 days that were missed?
Yes,
And are you also asking for attorney's fees associated with the need to file fourth motion and prepare for the hearing and attend the hearing?
yes, we are.
Are you also asking for Ms. Coolidge to be held in contempt for not paying the attorney's fees and the fine as she was ordered previously?
Yes.
And at this point, what kind of resolution do you see that would essentially get you the parenting time with your child?
Just for her to follow through and follow the order that has been set multiple times now. For us to reestablish the relationship with my daughter.
Do you believe that this recent denial in totality with all other denials of parenting time since the order entered could affect the bond between you and Mackenzie?
I wouldn't say it's getting any worse. It's not getting any better because she's not here.
Is there anything else you wish the court to know in relation to your motion for show cause?
Not at this time, no.
Thank you. I don't have any further questions to this witness, Your Honor.
Okay, thank you. Before I turn it over to Mr. Bland, just to clarify, Ms. Henderson, you had stated that the denials that you brought to the court's attention today are for the weekend of August 1st and August 15th.
Correct. It's Thursday through Sunday, Your Honor.
But then you've asked for, through his testimony, the makeup of 8 days. Those 2 weekends doesn't make 8 days.
Well, it's 9 a.m. on Thursday through 9 p.m. on Sunday. So it's
Okay,
3 overnights, but it's 4 days.
got it.
Yes,
4 days, but 3 over.
correct.
Okay. I was just trying to clarify. I didn't.
It's 9 a.m. on Thursday through 9 p.m. on Sunday.
Okay, thank you. Mr. Bland, cross-examination.
Thank you, Your Honor. All right, Mr. Hinkie, you testified that she sent some, I think your words were casual text messages. Is that correct?
Correct, yes.
Okay, and by she, I guess that's Miss Coolidge.
Yes.
And what was the nature of these casual, I guess, why are they casual?
I mean, it's just text message. It's not anything It's not like an urgent phone call. It's text.
Oh, okay, all right, I understand now. And in those, she indicated that she was not going to, I guess your terminology was show up to the parenting time?
That is correct.
Did she indicate to you in those text messages why?
I don't believe so, no.
Okay, you said later on that you were going back and forth on something and she wanted to talk about, I think your words were counseling. Do you recall that?
Yeah.
I'm sorry. And what did she want to discuss about the counseling?
She wanted to discuss the therapist and how she wanted me to drive 4+ hours all the way down there to have a meeting with them.
To meet with just the counselor, or to meet with the counselor and the child?
I'm not 100% sure.
All right. Was there a method set up so that you could play video games with your child?
That is correct, yes.
Okay, and I'm a little unfamiliar. What kind of games were you able to do like this?
Just several video games on the PlayStation.
Okay, and did you do that?
We have, yes.
All right, and do you do that on a regular basis?
I mean, I don't have that much free time. I'm not on the video games all day, no.
Okay, all right, but you have done that. Is that
A few
True.
times, yes.
okay? Are you able to communicate when you play these video games? I mean, is there an ability to chat, or do you have voice communications while you do this?
We have not talked with voice. I'm not sure if she has that ability.
Have there been chats during the game?
No,
Okay, you're just playing the games together.
correct.
All right, and that's happened on some occasions, but not on the regular occasions from what I'm getting.
Yes.
All right. Are you willing to meet with this counselor then?
Oh, yeah, we've reached out already. We've had conversations over email with the counselor.
All right. I don't have any further questions. Thank you.
Anything else, Ms. Henderson?
Yes, just briefly, Mr. Hanky, since speaking with a counselor, did that counselor get any of your perspective on parenting time or what has been going on, or no?
She's not.
So you simply discussed the treatment plan for Mackenzie and requested medical records?
Correct.
Okay, thank you. I do not have any further questions.
Anything else, Mr. Bland?
Just one based on counselor, or pardon me, on counsels. What was the nature of the treatment plan? Were you involved with it, or to be involved with it?
I was not been since the start. We just
And-
recently started getting emails with the whatever the reports of the sessions.
So you're getting session reports from the counselor?
Correct.
Okay, thank you. I don't have any further questions.
Ms. Henderson? anything
Nothing
else?
further, thank you.
So you can step down. Thank you.
Your Honor, may I get witness from?
Yes. Yep.
Back? Thank you. Thank you. What is your relation to Mr. Hanky and Mackenzie?
I'm Jared's mom, and I'm Mackenzie's paternal grandmother.
And did you in fact do transportation for pickup of Mackenzie for parenting time on August 1st?
Yes.
Could you please describe to the court what steps you took that day in order to get to your destination?
I arrived at 8:42. I texted Samantha at 8:45. I went to McDonald's to get proof of where I was. Between 9 o'clock and 9:45, I walked the perimeter of McDonald's looking for the two vehicles, which I never saw. And then I attempted to call her at 9:30, went straight to voicemail. And then I left at 9:45.
Thank you. And when you said McDonald's, that was the McDonald's referenced in the original order on Jefferson Avenue
That's
in
correct.
Fort Wayne. Thank you. And you verified that that was the right location when you went inside?
Yes,
Okay. You were in fact present during one of the exchanges that did occur and it was the same location?
that's correct.
Okay,
Yes.
thank you. And did you receive any response to your text message or the phone call?
Did not.
Did anybody pick up the phone when you called?
No,
Okay. And you waited for approximately an hour from the time that you arrived
yes,
and 45 minutes from the time of the meeting?
correct. Yes.
And did you end up driving home without Mackenzie?
Yes.
Is there anything else you'd like to state in relation to that trip?
No,
How much time did it take you?
so it's 2 hours one way, so just over 4 hours,
What's the wait time?
correct.
Thank you. And any idea on the cost of gas?
It's 126 miles one way. So, and takes 3/4 of a tank of gas, so I figured right around $50.
Okay, all right. Thank you. Anything else you would like the court to know in relation to that trip?
No,
Thank you. I don't have any further questions, Your Honor.
Mr. Bland, any cross-examination?
I don't have any questions.
Okay, ma'am, you can step down and thank you.
Ms. Henderson, we're not related. I just want to make sure, but she does share the same last name as me.
Oh, okay.
Ms. Henderson, could you please state your full name and spell your last name for the record?
Sierra Henderson, Henderson.
And how are you related to Mr. Hanky and Mackenzie?
I am Jared's significant other.
And how long have you known Jared?
8 years.
And how long have you been in a romantic relationship?
8 years.
Okay, all right. Were you the one transporting or set to transport Mackenzie to parenting time on August 15, 2024?
I was.
Tell the court what steps you took that day in order to get to the destination to pick up Mackenzie.
I left our home about 7 o'clock in the morning. I drove down to the McDonald's meeting location in Fort Wayne. I got there probably about 8:50-ish or so. I attempted to send a text to Miss Coolidge to let her know I'd arrived and when I was driving. And then I proceeded to wait until about 9:30. After that, I made my way back home.
Did you happen to walk around to see if there were vehicles parked?
I drove my vehicle around, yes, at about 9:15 and about 9:30 before I left.
Did you get any responses to your text messages?
I did not. I believe she has my phone number blocked. We both have Apple phones. My text was green, which usually means that the phone number is blocked.
Were you prepared to pick up Mackenzie and take her to parenting time at that point?
Yes.
Did you have to take time off work to do the drive?
Yes, I did.
And do you remember how much you spent in gas for that trip?
Probably about $50 or so. It's full tank of gas.
And at this point, how long did it take you from the time you left your home till when you returned?
I got back to work that day about 11:30, so about 4.5 hours.
Thank you. And you are certain that that was the right location?
Yes, the same location we go to every time.
And you know that because you participated in one of the previous exchanges that actually did occur?
Both that occurred, yes.
And that was the same location?
Yes.
Thank you. I don't have any further questions, Your Honor.
Bland, any cross-examination?
No, Your Honor.
Ma'am, you may be excused. Thank you. Henderson, next witness.
Your Honor, we rest at this point. That is all the witnesses we had, same witnesses we had almost every motion hearing,
Okay.
stating that my client was there and Mr. Bland's client was not.
Thank you. Mr. Bland, any witnesses?
No, Your Honor. Thank you.
Looks like that concludes the proofs in this matter. Ms. Henderson, any closing argument?
Yes, Your Honor, briefly. Unfortunately, this is our fourth time in front of the court on the same issues, and unfortunately, previous orders holding Miss Coolidge in contempt did absolutely nothing for the parenting time to occur. She continues to ignore the court orders. She continues to not show up. In fact, at the last hearing we had with referee Snyder, she stated that she intends to withhold the child, and clearly that is done in bad faith, as is referenced in referee Snyder's recent order. We're asking, Your Honor, for the makeup parenting time to occur, and that would be 4 days and 3 overnights times 2, so Thursday through Sunday, 9 a.m. through 9 p.m. My client has already been granted a significant amount of parenting time to make up, but unfortunately, he's not able to exercise that parenting time if plaintiff continues not to show up to the parenting time exchanges. Significant distance between the parties does make it a little bit easier for Ms. Coolidge not to show up to those exchanges. I don't know what solution the court has in that matter. Possibly having my client going to plaintiff's home with a peace officer to retrieve the child, possibly some other way for him to actually get his parenting time. But we're asking for that makeup parenting time to occur and for Ms. Coolidge to be put on notice that the court order has not been changed and it needs to be followed. Another couple things that we referenced in our motion relate to her non-compliance with the previous contempt order, specifically regarding payment of attorney's fees and fine to defendant's counsel's office, totaling $547.50. My client keeps incurring very significant attorney's fees, and he's still here. He is determined and devoted to getting to see his child. For court's reference, it took him about 4 years to get that order, and now that we have the order, nothing has changed because his parenting time still does not occur. We're also asking for attorney's fees associated with the need to file the motion, argue the motion, and then attend the evidentiary hearing in front of Your Honor. I can prepare a bill of costs. I have submitted bill of costs associated with the third motion earlier today per referee Snyder's request. So I can do the same thing for this motion once the hearing is over. At this time, Your Honor, I'm asking for the court to do something to make Ms. Coolidge take this order seriously. And I think my client has made it very clear on the stand. He just wants to see his child. He is not here for any other reason but to reestablish the bond and the relationship with his daughter. Thank you.
Thank you. Mr. Bland, any closing argument?
Just briefly, Your Honor. Well, I'm also a big believer that court orders ought to be filed or followed. I mean, they're there for a reason. And obviously there was times when this order was not followed. I think the real question is why. Without being able to present her testimony, it's kind of difficult to present the why. And there was, of course, at least a preliminary motion to try to modify the parenting time. I would simply say this, if she were here, I think she would tell the court that she didn't think it was necessarily at this speed in the best interest of the child, but she's not here, so I'll at least make that offer of proof on her behalf. She's always indicated to me that she thought parenting time should occur. She just didn't think it should be for weekends at a time. Be that as may, the order does exist. I believe that this order will be complied with. I think obviously when she gets word of the seriousness of this, I think it'll compel her to do so. It still may need to be modified in the future based on how the child adjusts to it, but that's for another day. The only thing I would ask at this point, Judge, is certainly the court has issued a bench warrant for a non-appearance. If the court wants to make orders as to sanctions, that's fine. I would ask that that not include additional jail time, at least until we can clear the bench warrant that the court has issued already. Thank you.
Thank you. Anything else, Ms. Henderson?
Your Honor, just a brief response to Mr. Bland's comment about parenting time. Ms. Coolidge has not complied with the scheduling order for the original hearing. She did not like the decision that the referee rendered. She then filed a motion for reconsideration that the court denied. She filed a motion to set aside recommendation. The court denied that. So again, this is just Ms. Coolidge not liking the order and choosing not to follow it. It has absolutely nothing to do with the child's reaction or with the child struggling with parenting time. In fact, if you read referee Snyder's latest order, he questions the validity and credibility of the statements regarding the child's reaction to the parenting time or even the counselor involvement. So all of that again signifies to my client that Ms. Coolidge literally is going out of her way to actively prevent the contact between the child and her father. And that is absolutely not okay. And we're asking for the court to stop that.
Okay,
Thank you.
Well, the court would note that in this particular matter that a order regarding parenting time child support was entered back on April 12, 2024, that sets forth the parenting time that the defendant has been following in this particular matter. After that order was entered on May 21st, 2024, it was a hearing before the referee, and an order was entered at that time providing for a makeup parenting time of 3 hours. And that in fact also ordered the plaintiff to pay attorney fees of $447.50 within 60 days of that hearing. That neither of those was complied with. Next there was a hearing with the referee, and order was entered on 6/28/24 for a second finding of contempt. And that was from the denial of May 11, 2024. And the referee provided for makeup parenting time of 12 hours and awarded the defendant $100 in attorney fees to be paid within 30 days. Subsequent to that, on August 9, 2024, the referee did its third finding of contempt in this matter, which again would order makeup parenting time in this particular case for periods of the weekend or the week, the 4 days from June 20, 2024 to June 23, 2024, July 4, 2024 to July 7, 2024, July 18, 2024 through July 21st, 2024. And that at that point awarded and in fact ordered the plaintiff to pay attorney fees. And as Ms. Henderson says, those are just recently, that bill of costs was submitted. We now have the current proceedings concerning the time of August 1, 2024 through August 4th, 2024, and then the time of August 15, 2024 through August 18, 2024. It does appear to the court in this matter that the plaintiff is simply not complied with the orders. She's flaunting her contemptuous behavior in this matter before the court and not complying with any of the orders. And the court would note that this is a short period of time, simply from the first order that occurred back on May 21st from the order of April 12, 2024. It's clear to this court, based upon the history in this matter, as well as this current proceeding, and again, refusing to appear in this matter, notwithstanding that the court had ordered in-person attendance and had reiterated that to Mr. Bland's office when Mr. Bland contacted my office to inquire if, again, it would be possible for her to appear vis-a-vis Zoom. She clearly is not going to comply with the orders of the court. As a result, the court find that to be wrongful and contemptuous. The court is going to hold her to be in contempt in this particular case. The court would order the additional makeup parenting time of 4 or 8 days and 3 overnights. for the times as set forth from the weekend of the August 1st and August 15th, and would order that would occur forthwith. The court would further find in this matter that the testimony is shown from the defendant's mother that she in fact appeared at the pickup place, that she was very familiar with that she was there, that she arrived, as she said, she walked the perimeter of the McDonald's to make sure that she did not miss the plaintiff, and she waited for approximately an hour before she left, and then she proceeded to drive 4 hours to get back home. Then Miss Henderson, not Anya Henderson, but the girlfriend Henderson, had stated that she appeared the weekend of August 15, 2024, that she drove and left, and she arrived at approximately 8:50 a.m., that she waited until 9:30 a.m., that she drove through the parking lot at approximately 9:15 a.m. and again at 9:30 a.m. before she left and went home, and it took her approximately 4.5 hours. And she acknowledges that this is the same location that she had been previously to, again, provide the transportation and pick up the minor child, and the plaintiff has simply not appeared. So what the what the court is going to do, in addition to holding her in contempt and having the make-up parenting time, the court is going to reserve on the sanctions in this matter until such time as Ms. Coolidge is before this court, and at that time, the court will render a decision on those particular sanctions. The court would, if you wish, Ms. Henderson, you can put in the order that the defendant would be entitled to go to the plaintiff's home to pick up the minor child if he wishes to, in fact, make that entire trek, and that he is entitled to enlist the assistance of any police officers to help him to acquire the child in his care and custody, even to the extent if the officer needs to enter the home to do so. Anything else, Ms. Henderson, before we conclude?
Your Honor, just to clarify, you said 8 days and 3 overnights. Did you mean 6 overnights?
6, yes.
Okay, thank you.
I was thinking of the individual, 6 overnights or 8 days.
And then you stated forthwith, Your Honor, all of referee Snyder's make-up parenting time orders state that make-up parenting time shall not be taken before November 1.
I'm gonna say all of the parenting time that's been missed, all the makeup time will be made up at the time that, we'll say forthwith. So each weekend, from the time that she starts to allow the makeup parenting time until all of the makeup time is concluded.
So all at the same time. Am I understanding you correctly?
Each successive weekend,
Okay,
not at the same time, so that, because I take the child's in school, the child has to go to school.
she is not. She's homeschooled.
Oh, okay. I'm sorry, I was not aware of that.
Yep, she's
The
homeschooled.
court would then allow the parenting time to then, in fact, encompass all the consecutive missed makeup parenting time. I was not aware of that, nor did I see it in the file anywhere.
Yes, Your Honor, that was part of the initial hearing with referee Snyder. And that's why he ordered Thursday through Sunday, because the child is not in formal school.
I thought there was something unique to her schooling, that maybe she didn't have schooling on
Mm-mm.
those days or something of that nature.
No.
Okay, anything else, Ms. Henderson?
I don't think so. Just to clarify, Your Honor, again, to make sure I don't misunderstand. So once he gives, does the court require for him to give 30-day notice?
No,
No. And is there any notice required?
I'm not going to require any notice. The order is the order.
Okay,
And she will need to follow that order, and especially as it relates to the makeup.
and so if my client chose to exercise all of the time that was previously granted to him, just to clarify, he could start with the 3 hours and end with the 6 overnights you ordered today and exercise it all in one chunk?
Correct.
Thank you.
Yep.
And because it is a judge order, it supersedes referee Snyder's requirement for notice in
Yep.
November. Okay, thank you.
Anything else, Mr. Bland?
The only thing I can think of, I understand the child's homeschooled, but if dad were to take all that time, I would ask that he be ordered to cooperate with the homeschooling program.
Well, presumably he would do that, and I'm not concerned about her education. I'm more concerned about her visiting her father and having that time. So, obviously, it would hope that that would happen, but again, we're going to deal with one thing at a time. This time is to get the parenting time commenced, and then we'll deal with the.
Thank you.
Thank you all. The court will stand in recess, and you're free to go. Have a good day. Go ahead, have a seat. Yeah, staff just brought up, I had not addressed the attorney fees for today's proceeding.
Oh.
Ms. Henderson, you should have caught them.
Well, I figured that would be encompassed with the sanctions. I wasn't sure.
Well, no,
Yeah.
I'll order that the plaintiff would pay the attorney fees for these proceedings based upon Ms. Henderson providing another bill of costs in this particular matter. And again, if it's not objected to, then I'll go through. If so, then we might have to have a reasonableness hearing at that point.
Thank you, Your Honor. And what about the request for the attorney's fees that has already been granted? Is the court giving her any type of, hey, you must pay by such date?
Well, she's already passed that. So the court will, she's already delinquent on that. What happens, in fact, I had thought about that previously, and I will address that. Ms. Henderson, the court will grant you a writ of garnishment and/or attachment to acquire any and all attorney fees ordered in this matter. And you include that in the order as well.
Thank you. And for the bill of costs from today, Your Honor, is there any deadline for her to pay those attorney's fees?
The court would order that those would be paid within 45 days of the court entering the order for those fees. Anything else?
I don't believe so, Your Honor.
Okay, Mr. Bland, anything else?
No, thank you.
Okay, we will stand in recess.
Thanks.